Assalamualaikum and very good morning. My name is Muhammad Daniel bin Hasmin. I'm from AT11048. I'm doing this video presentation for the course AGR255 Legal, Ethical and Social Issues in Plantation. This video presentation for the assignment newspaper cutting, and the topic for this video presentation is pembantu rumah didera tidak dibayar gaji diselamatkan, that I took from the Sinar Harian newspaper, and this is the example of Sinar Harian newspaper. I have 7 points in my presentation. The first one is article summary. This is the review of the article. The second one is the key issue 1, the issue in the article. The third is recommend solution 1. This is the solution for the issue 1. The fourth is the conclusion 1. This is the best solution for issue 1. The fifth one is key issue 2. This is the second issue in the article. The sixth one is recommend solution 2. This is solution for the issue 2. And the last one is conclusion 2. The best solution for the issue 2. Let's move on to the introduction. Okay, the article summary or the introduction. I choose the article pembantu rumah didera tidak dibayar gaji diselamatkan, authored by Muhammad Fazli and published on 24th February 2022 for this project. There have been several incidents of employers abusing their employees. For example, the employer of this foreign worker had exploited the employee by failing to pay the worker's wage and mistreated the employee several times. For the year 2021, the expected amount of unpaid wages is Rm 8,400 for the employee. And furthermore, the employer took the employee's passport since the employee worked for the employer despite lacking a valid work visa. Last but not least, this problem will be investigated further under Section 12 of the Anti-Trafficking and Anti-Smuggling of Migrants Act of 2017. And this is the review about this article. This article is about the employer abusing the employee. Key issue 1. Exploitation of the employee. To achieve harmonious industrial relationship is by maintaining a good relationship between the employer and the employee. This is because exploitation issues are not rare in our country. There have been several allegations of foreign employees or workers being exploited by the employer. In this case, the employer exploits the employee by failing to pay the employee's salaries, and the employer treating the employee improperly. The employee should not engage in such behavior toward the employee. This is because the employee that engaged in such behavior can be sued under the law. The trade union association and the government take this issues seriously because these issues can do considerable harm to both employer and the employee. Recommend solutions for key issue 1. Solution 1. Reporting. The first solution is reporting the employer to the labor court. This is because in the Article 6(1) and 6(2) of Malaysia's Federal Constitution stipulates that all forms of forced labor and slavery are illegal on Malaysian territory. The Article 6(1) declares that no person should be held in slavery. The word "no person" in this article denotes that neither local nor foreign employees may be held in slavery or any other kind of enslavement. This demonstrates that any type of labor force, whether local or foreign, is illegal in Malaysia. If any other parties or organizations are proven to be guilty of engaging in forced labor, they might face punishment in the labor court. Furthermore, the major employment legislation in Malaysia to guarantee workers' minimal rights is the Employment Act 1955 Act 265. The Act stipulates the minimal protection of the rights of both local and foreign employees in Malaysia, with the exception of domestic workers. The Act 265 mandates adequate compensation for workers, overtime wage, and payment deduction a limited number of working hours per day, maternity leave for female employees, and annual holidays. Moreover, according to Act 265, if an employer fails to offer all of these benefits to a worker, the employer can be punished in the labor court. Finally, both the employer and the employee must adhere to the norms and laws outlined in the Employment Act 1955, since both the employer and the employee are obligated by it. The next point in recommend solution for key issue 1 is solution number 2, joining. The other solution for this issue is joining the trade union association. This is because both employer and the employee have the right to join the trade union association for their mutual benefit. The migrant employees in Malaysia are covered under the Trade Union Act of 1959. This act protects the rights of employees and the employers to form unions, and migratory workers can participate in trade union events. If the employee joins a trade union, he or she can bargain with the employer to acquire what they want. Wage increase, additional rest time, and bonus pay are just a few examples or terms that the employee can negotiate with the employer. The Malaysian Industrial Relations Act of 1967 protects the rights of migrant workers as well. If an employer forbids an employee from joining a trade union, the employee may submit a complaint with the Director General of Industrial Relations. Finally, a trade union can act in the improvement of the employer and employee relationship. The last point for key issue 1 is conclusion. Finally, the best solution to overcome this key issue 1 is solution number 1. This is due to the fact that by reporting the employee to the labor court, the employee can obtain compensation and benefits from the employer if the employee is proven guilty. However, if the employee files a complaint with the labor court, he or she may lose his or her employment. Even though the employee may face loss of jobs, this approach is the finest way to protect the foreign worker from being abused by the employer. To summarize, all that has been said thus far, solution 1 can assist the foreign worker in this case. The next point is key issue 2. In this article, the employer was keeping the employee's passport since the employee worked for the employer. A passport is extremely important for a foreign worker. This is due to the fact that the passport is one of the most important documents that the foreign worker carries with them. Furthermore, foreign workers must acquire a working permit before they may work in Malaysia. Otherwise, they could be arrested and deported back to their home country. However, the employer has no authority to confiscate the passport of a foreign worker, whether by pleasure or force. This is because passport detainment is illegal by the Passport Act of 1966 and other domestic regulations governing migratory workers. Furthermore, the worker should have the right and flexibility to change jobs at any time. This is not appropriate behavior, and the government should take action in this situation of the passport detainment. Let's move on to the recommended solution for this key issue 2. One answer to this passport detention is to implement the Passport Act of 1966 in the employment environment. This is because the Employment Act 1966 specified the regulation and laws that the Malaysia society should obey. Furthermore, this is an act dealing to the possession and production of travel documentation by people entering or leaving Malaysia or travelling within Malaysia, as well as things related therewith. According to the Passport Act 1966, anyone who without lawful authority has in his possession any passport or internal travel document issued for the use of some person other than himself is guilty of an offence and if convicted faces a fine of up to 10,000 ringgit or imprisonment for up to 5 years or both. To summarize all that has been discussed so far, the Passport Act of 1966 can assist in bringing justice to the foreign worker who has had their passport detained by their employer, such as in this article. Recommend solution for key issue 2, solution 2. Another solution to this problem is to refer to section 12 of the 2017 Anti-Trafficking and Anti-Smuggling of Migrant Acts. This issue will also be further investigated under this act. This is because breaches of human rights can take many forms, including forfeiture one or more of the human rights to which he or she is entitled. Some infractions may be regarded activities outside the scope of crimes against humanity. Furthermore, human trafficking is a global crime in which individuals are traded and exploited for profit. To prevent and appropriately represent the severe nature of the offences, the Anti-Som Amendments specify severe sections including as extended jail terms and or the introduction of wiping. For example, Section 13 of Anti-Som introduced the punishment of imprisonment for life or for a term not less than 5 years and wiping for any person found guilty of the aggravated offence of human trafficking. And Section 26A increases the maximum term of imprisonment for the offences of migrant smuggling from 15 to 20 years. Finally, by enforcing the laws established to maintain the harmony of the environment in this country, we can avoid this issue from getting out of hand. Last part for this presentation is conclusion key issue 2. Finally, solution 2 is the finest option to overcome this issue. This is because human trafficking and migrant smuggling are illegal in Malaysia. Furthermore, the Anti-Trafficking and Anti-Smuggling of Migrant Acts of 2017 was created to assist in resolving the issue of human trafficking and migrant smuggling. According to the Section 13 of the Anti-Trafficking and Anti-Smuggling of Migrants Act of 2017, anyone found guilty of the serious offence of human trafficking faces life imprisonment or a period of not less than 5 years in jail and wiping. To summarize what has been said before, the Anti-Trafficking and Anti-Smuggling of Migrants Act of 2017 is a legislation that may be utilized to protect migrants from being abused by their employers. That's all for my presentation for this newspaper cutting report. I hope that you understand what I have been said before, and thank you very much.
I should fuck her in a Benz.